is in line with our service delivery blueprint, which is Vision 2023. Through such platforms, we are complying to Section 182(5) of the Constitution of the Republic of South Africa, read with Section 8 of the Public Protector Act, where it provides that the Public Protector may publish her findings, and in that particular aspect, there are exceptional circumstances where sometimes I might not publish the reports because of confidentiality. Therefore, I also determine the way I publish the reports. Sometimes we can just publish in our website, then sometimes we will call a media briefing like this one. So I will reveal shortly my findings on a number of matters concerning the Rustenburg Local Municipality, the Northwest Department of Education, Sport Development and Department, the Gauteng Department of Human Settlements, the Master of the High Court, Mzimkhulu Local Municipality, and the City of Tshwane matter, which we call it the PEU, which were the tender which was granted to PEU. Lastly, I'll also release my findings in matters that have to do with the alleged conduct or misconduct or improper conduct by the National Director of, National Treasury Director General, former Minister Mbalula, the Western Cape Premier. This relates to issues of the Executive Members Ethics Act. However, since we are on the verge of shutting our doors to 2018, it is worthwhile that one briefly indicate what we've done for the past 12 months. And the good news is that we have a lot of highs which outweighs the lows. And in exceptional circumstances, we have made sure that good governance is reinforced, and we've dealt with the root causes of maladministration in the country. Examples of our impactful efforts include the 30 reports which we've issued, excluding this 8 we will be issuing today, and that reflected in the report of Pick It Up, Ventersdorp report, Gasekhonyane Municipality in the Northwest, and various other departments. I must indicate that our Northwest office is the one which has performed exceptionally well this financial year in issuance of reports. And reports help because we can guide departments on what are the root causes of any maladministration, and also if they comply to that, then we can curb the scourge of corruption, because we know that corruption thrives where there's maladministration. We've also issued reports that touched on the lack of farmer support, the vulnerability and harmful exposure to radiation and chemical hazards for the South African Nuclear Energy Corporation workers, the plight of whistleblowers from the Northwest, from the Mzimkhulu whistleblowers, USASA whistleblowers, and we've also dealt with some shortcomings in the implementation of the South African Citizenship Act by the Department of Home Affairs. Again, you know that we've issued various reports relating to Executive Members Ethics Act, where it involves ministers in this cabinet. There was also a report that drew public attention, the Deputy Speaker of Limpopo Provincial Legislature, especially the cell phone allowance allegations, and also the Premier Zille colonial tweets. I think this one, you know that we've been taken on judicial review and the matter is sub judice. So this is obviously not an exhaustive list of what we've done, but I engage the public regularly. We also had our public road shows to make sure that we engage with the public. I must indicate that at least we have finally managed to sign an MOU with the Department of Justice, and we thank the Director General of Justice, who worked very closely with our CEO so that we can manage to expand our footprint, which is one of the pillars of Vision 2023. And again, this year, Public Protector South Africa has been appointed as the president of AYOMA, which is African Ombudsman and Mediators Association, a continental body of 44 public protector-like institutions in Kigali at the end of November. This is a very strategic role which South Africa will play, especially relating to the Agenda 2063, where it relates to silencing the guns by 2023. Especially in other countries, we've got mediators, we've got ombudsmen, we've got public protectors, and we play a key role, especially in mediation or alternative dispute resolution and prevent conflict in various parts of Africa. Also, various ombudsman deals with issues relating to maladministration. Therefore, that will help. In my role then as president, I will also make sure that we focus our energies in the next 4 years in making sure that all the ombudsmen, they comply or the implementation of the OR Tambo minimum standards of effective ombudsman institution and cooperation, which stresses that all ombudsman institutions should be provided for in the constitution, should be independent and autonomous, and as well should be fully funded, and especially to be able to deliver on their mandates. In line with the declaration, especially which was adopted at the Kigali conference, we've agreed that we will work closely with other such institutions. Also, we will have to work closely with the African Union Commission, because also those issues are at their core. The laws from our side included our internal affairs, especially our sister organization, the AG, where we had issues of irregular expenditure, which were largely issues that preceded my appointment or legacy issues. But then we are working very hard as a collective to make sure that we comply, because we are also an institution which should be complying. And we've dealt a lot with bread and butter issues. I've been saying several times, our investigations, 90% to 95% deals with bread and butter issues and service delivery related issues. And 5% we deal with the so-called high profile cases, or the cases where the members of the executive are implicated. So the reports which I'll be issuing, the Benyenye investigation, we were investigating the failure by the Rustenburg local municipality in the northwest to award a tender to a Mutsokhapeli Projects Cooperative. And this cooperative was disqualified because it was alleged that their members were less than the required number. And their tender amount was around 2.5 million, but then they awarded this to a contract or cooperative which quoted the municipality 3.7 million. On investigation, we discovered that the municipality violated the legislation, because when we investigate, we check what happened, what should have happened, what are the prescripts which should be complied with. And in this particular instance, we discovered that the cooperative had, in fact, for a cooperative to be deregistered, the members should be less than 10 in a period of 6 months. So it was still very early in that particular aspect. So the findings were that the municipality should ensure that the complainant is refunded or reimbursed the amount of 1,500 with interest for paying for the tender documents, and further to issue an apology letter to the complainant. The next one is a Landani matter, where we've investigated again the Northwest Provincial Department of Education and Sports Development, where they failed to implement an audit report relating to allegations of fraud, corruption and nepotism against the Delareyville area manager, Mr. Mbipa. So the complaint was lodged with my office in February 2014. The findings in this particular instance was that, in fact, the complainant also requested that he was transferred, and the transfer prejudiced, in fact, he was prejudiced in this particular instance as the complainant, but then we discovered that The complainant requested the transfer, and it was done properly, but then the finding was against the department for not implementing the audit findings. The remedial action, I directed the administrator, because we know that Northwest is under administration, within 30 days of the date of this report to implement the recommendations of the internal audit report. I further directed the administrator to take disciplinary action against the implicated officials of the department. The next report relates to Hlungwani. Hlungwani is the complainant from Limpopo, Provincial Department of Education, where the department failed, or the allegations that the department failed to appoint Ms. Hlungwani to a permanent position in 2016, and the complaint was received last year, March 2017. The complainant alleged that she worked as a temporary teacher at Mulinginisi Primary School, and in 2016, in fact from 2015 2016, the department advertised the post. She applied, but then there were 4 who were appointed. The 3 resumed duty, but she was told that she cannot resume her duties. But then she continued to be employed as a temporary employee. On analyzing the complaint, I decided to investigate, and following the investigation, the allegations that the department improperly failed to appoint the complainant to a permanent position is substantiated. She did apply for an advertised permanent position, was shortlisted, was successful. So the governing body also improperly failed to submit the interview panel's recommendation to the head of department. The finding was that had the complainant been appointed on a permanent position, she would have been entitled to a gross salary of 20,475, including benefits for a period of 9 months. Therefore, the remedy is that the Superintendent General of the department must issue a letter of apology within 30 days, pay the difference of a salary between the temporary teacher and a permanent teacher in the period in which she was prejudiced, compensate the complainant a full salary and all benefits she lost, calculated from January 2017 when she was unemployed, because there was a period when she was unemployed. The next reports relate to Alexandra Contractors. I investigated the allegations of maladministration and due delay in effecting outstanding payments to the Alexandra Far East Bank contractors in relation to the tender which was issued then. The complaint was received from Mr. Ntombela on behalf of the 45 other Alexandra contractors, although 3 others withdrew from the project, so it means we investigated the 42. In the main, the complainants alleged that they were awarded a tender by the Gauteng Provincial Department of Human Settlements for the construction of the low-cost housing between 1998 and 1999 in Alexandra Far East Bank. They also alleged that they lodged the complaint with the department in the year 2000. There were, in fact, there were balances which were not paid, and this matter, a lot of them also faced a lot of challenges, or it impacted on their finances, being SMMEs. Following an investigation, I found that the department failed or the undue delay to pay the outstanding balances to the complainants. The evidence at my disposal indicates that there existed a contractual relationship between the 42 of the 45 complainants to construct these houses. And the information received from the complainants about the number of houses built by each one of them and the outstanding balance owed to them by the department is contradictory. So we were relying both on the department and the complainants. You'll find that some of the information from the complainants, there was no sufficient supporting documents. So we had to rely on the Gauteng Audit Services audit report in this matter. Therefore, the finding was that the department should be paying the outstanding amounts, which are ranging from 462 rands to around 919,588. So this must be done within 30 working days of the publication of this report. And the department should be appointing an independent quantity surveyor to conduct a further assessment or audit of the work done and the amount payable to the 9 others, because we had to have a detailed investigation. There were others where we never had documentation or supporting documents. Therefore, we request the department to conduct that investigation after determining and pay those outstanding balances. I'm glad that at least a lot of the construction companies or these SMMEs will be able possibly to revive their businesses because they were impacted seriously. And I must indicate that the Department of Gauteng Human Settlement was very cooperating in this particular instance. The next report relates to Dube. Is a complaint of allegations of maladministration against the Master of the South Gauteng High Court. This had to do with alleged irregular appointment of and failure to supervise a provisional liquidator, resulting in prejudice to the complainant, Mr. Sipho Dube, the Managing Director of Ndulwini Resources Limited. He was placed under provisional liquidation as per the court order, South Gauteng High Court, Johannesburg, and the company has been placed under final liquidation as per court order. In the main, the complaint was regarding the process pursued by the master in appointing the provisional liquidator of the company, as well as failure by the master relating to the supervision of this provisional liquidator. The master did not dispute the said appointment of the provisional liquidator, but disputed that it had the authority to consider the provisional liquidator's conduct relating to the maladministration. So to this, the master argued that he was functus officio, as the decision made by the latter could not be reneged upon, as such exercise falls exclusively to be within the functions of the court. I then investigated whether the master improperly appointed the provisional liquidator and whether the master failed or refused to revoke the decision to appoint, and as well failed to determine a policy. In fact, whether the minister also failed to determine a policy providing for matters relating to liquidators, because this impact the companies if there's no policy, because there is a 48-hour policy which is being utilized, and that policy is very detrimental to small businesses who are facing liquidation. So the master on more than one occasion referred to the appointment in line with the legislation and the minister, especially this policy. In fact, there was a lacuna in this particular matter. So the findings are that the master failed to perform his functions and to enforce his powers in terms, or her powers in terms of the relevant legislation, especially the Companies Act, and the master also failed to discipline or take any action against this provisional liquidator when they were not doing their work. The minister also failed to determine a policy providing for matters relating to liquidators. It is noted that the minister determined the policy, and this policy was, in fact, some of the other liquidators took the minister to court, where they interdicted the minister. So the minister unsuccessfully challenged the decision of the Supreme Court of Appeal, and then the Judicial Matters Amendment Act specified the necessity of a policy when appointing provisional liquidators. So the absence of this policy leads to a lack of uniformity in the exercise of the discretion by the respective masters. Therefore, sometimes it will lead to abuse of power. Although the policy was subsequently developed and set aside by the courts, the minister's failure to also timeously developing the policy and the regulations or directives on the appointment process. In this particular instance, the minister failed to develop the process, and the finding is that the Minister of Justice should, within 6 months, develop this policy so that there is a standardized way of dealing with such issues. And the Master of the High Court must, within 3 months from the date of this report, develop and implement directives and guidelines regarding the exercise of the Master's discretionary powers in the appointment of provisional liquidators. The next report relates to PEU. We call it PEU. This we've investigated, falls within the city of Tshwane, relate to maladministration and irregular awarding of smart prepaid meter contract by the city of Tshwane, and a subsequent cancellation thereof. The first complaint was received from Mr. Richard Botha and Mr. Giso Du on behalf of Kusasa Healthcare, who had approached the public protector in January 2013. So this is one of the backlog cases which, when I joined the institution, I had hoped that we would have issued the report. I think DPP has been following up on this matter. Finally, we are issuing the report. The complainant further alleges that he conducted research with his business partner and came up with the concept of smart prepaid electricity meters. So the allegations were investigated. We received a second complaint, which was from Advocate Alberts, a member of parliament from and the Gauteng leader of FF Plus in 2015. So requesting the public protector also to investigate the procedures followed in granting the tender to PEU, and whether PEU Capital complied with all the requirements, and non-compliance by PEU with the contract, and why did the city of Tshwane initially accept the tender for such a high amount, and why has the Tshwane municipality cancelled the tender, and what is the agreement with regards to funds already paid, who is responsible for the tender or contract being cancelled, and the agreement reached between the parties. So the complaint received before the High Court matter was concluded. So we had to also await the court judgment, which was decided upon in the Gauteng High Court. And then I'm precluded to investigate court decisions by Section 182 of the Constitution. So the court order was issued on the 31st of October. The focus of the investigation then had to change. I have noted some aspects of the first complaint may have been addressed by the court judgment, and on analysis of the complaint, I decided to investigate whether or not there were any irregularities, improprieties in appointing and awarding the tender to PEU, and I also investigated whether or not the city followed a due process in awarding the smart meter contract to PEU. I further investigated whether or not the former city manager, in the awarding of the termination of the smart prepaid meters contract, failed to manage the financial administration and execute his fiduciary duty as accounting officer. I found that the allegation that there are irregularities was substantiated. The city did not conduct due diligence and therefore awarded the tender to a company that was technically insolvent and did not have any assets required to ensure that they have the capacity and ability to execute the contract. The city failed to conduct the necessary verification as requested in their supply chain management process. The city awarded the contract to PEU even though it did not comply with the requirements of the bid. And the company required to be registered with the Financial Services Board, and that those requirements were not met. The city failed to take action against PEU Capital for not complying with the condition of the tender that required them within 40 days to register as a vendor on the city's database. and the conduct of the city was in violation of their supply chain management policy, as well as a violation of section 195, 1B and F of the Constitution, which provides that efficient, economic and effective use of resources must be promoted in public administration, and accountability is key. So the city's conduct in this regard constitute improper conduct, and the findings were that the allegation that the city did not follow a due process in awarding was substantiated. The allegation that the former mayor, in awarding and terminating of the contract, failed to manage the financial administration of the city and execute his duties in honesty is substantiated. And in fact, all the council approved the master service agreement with PEU based on the reports that it was presented by the former city manager to a council meeting. So the city manager did not comply with the provisions of Section 61 of the MFMA, and the city manager failed to comply with his duties in terms of Section 61 and 62 of the MFMA. So the conduct of the city manager therefore constitutes improper conduct as envisaged in Section 182 of the Constitution, and the findings are that, in fact, the remedial action are that the current accounting officer to take appropriate action in terms of Section 62(1)(e) of the MFMA against the officials implicated in any irregularities in the award of this tender for the installation of the prepaid meters and take appropriate action. The Speaker of the municipality of the city of Tshwane must take appropriate steps to ensure that the council report the conduct of the former municipal manager and officials implicated in the tender irregularities in this matter to the South African Police and the DPCI, Directorate of Priority Crime Investigation, and for violation or in terms of Regulation 10 of the Municipal Regulations on Financial Misconduct. The next report relates to an anonymous complaint received against the Director General of National Treasury, Mr. Dondo Mkhwebane, for failure to disclose that he had a criminal record in his application form for the director position. The complaint was lodged in August 2017. It was alleged that Mr. Mkhwebane applied for the DG post, and in completing his Z83 form, application form, under the question where he was asked, have you ever been convicted of a criminal offense or been dismissed from employment, indicated no with the mark. It is alleged that he accordingly rendered false information to National Treasury during the application process for his employment, and he had a criminal record in terms of, or in that he had been previously found guilty under the contravention of the Road Traffic Act. In essence, the complaint is that Mr. Mkhwebane misrepresented facts about his personal record, thereby concealing pertinent information which reflected on his suitability for this critical position, to which he was appointed by former Minister of Finance, Mr. Gigaba. Upon analyzing the complaint, I decided to investigate whether Mr. Mkhwebane failed to disclose his criminal record and whether such is an improper conduct. Also investigated whether the conduct of former Minister Gigaba in the appointment of the Director General was improper. Following the investigation, I found that the allegation that Mr. Mkhwebane failed to disclose the criminal record on the application for the position of the DG is substantiated, and it is right that Mr. Mkhwebane had a duty in law to act honestly and in good faith towards his employer, where he was required to disclose this. Mr. Mkhwebane, however, did not disclose this duty towards the employer, and further he discovered about this criminal record when he applied for the DDG position in 2015, and in so doing, Mr. Mkhwebane failed to meet the standard imposed upon him to act with integrity and honesty towards the employer. I also found that the former minister in the appointment of the DG was improper, that the minister should have made sure or satisfied himself about all the processes followed, and when the evidence was presented to him, he needed to act with the due diligence. So former minister proceeded to approve the memorandum for the filling of the position 30 May 2017, therefore tacitly condoning the impropriety. So as a remedy, I have directed the President to take appropriate disciplinary action against Mr. Mkhwebane in terms of Section 16A of the Public Service Act for dishonestly making false representation of material facts, non-disclosure of a criminal conviction. This must happen within 30 days of this report. I further directed the President to note my findings, observations, and take the following representative within 60 days to cause a review of the current screening and selection of the DGs and heads of departments. This is for the purpose of ensuring that the executive authorities of the departments comply with their obligation in terms of Section D of the Public Service Regulations and the SMS handbook to verify all relevant information pertaining to the suitability of candidates prior to the engagement with the Minister of Public Service and Administration as well as Cabinet, and align the selection, recruitment and appointment process accordingly, and to align it with the recent court judgment or decision where the former DG of Home Affairs, Apleni, took the minister to court, and Mr. Mlengane from Department of Agriculture. So that needs to be aligned with Section 12(1)(a) of the Public Service Act. The next report relates to Mzimkhulu. This was an own initiative investigation after the reports in the media where it suggested that Councillor Makaka was killed for having queried alleged maladministration and corruption associated with the restoration of the heritage of the dilapidated Mzimkhulu Memorial Hall. During the period July to September 2017, there were various media reports. There were allegations that a tender for upgrading the Memorial Hall was awarded to Loiso Consulting in the amount of 1.3 million. And then further that the municipality awarded another tender to upgrade for an amount of 17 million. And however, then the project had not been completed. They alleged that Loiso abandoned the project, and there were also allegations that this Loiso had some relations with some of the officials of the municipality. And those are allegations that Loiso could not complete the project, and then the project was awarded to Sifiso Building Constructors, where the municipality had to pay the remaining 15 million. And the municipality advertised another tender where they awarded this contract to Buyeye Consulting, and the amount was 14 million. There were allegations that up to 37 million was spent. Those were the allegations, and it helps that we then as an institution should be conducting an investigation to determine all these issues. So the process which was followed was also to interview whistleblowers, especially Tabiso Zulu and Studa, relevant officials of the municipality. I think you are aware that this matter also led to the issuance of the report against the Minister of Police for not protecting these whistleblowers who were alleging that there were threats against their lives. Having considered the allegations, I decided to investigate the following: whether Mzimkhulu municipality obtained the requisite permit from AMAFA, KwaZulu-Natal Heritage Resource Agency, to do alterations to the Memorial Hall, and whether, in fact, whether the AMAFA also, or the agency, properly exercised its oversight in this process of refurbishment, whether the procurement process followed by Mzimkhulu in appointing the service providers for the refurbishment and restoration of the Memorial Hall was in accordance with the system which is fair, equitable, transparent, competitive, and cost-effective in terms of Section 217 of the Constitution and the relevant supply chain management policies. Whether the municipality also exercises oversight, especially the council, oversight over this process. I found that the allegation that the Mzimkhulu municipality went ahead and made alteration to the Mzimkhulu Memorial Hall, a heritage site, despite not having the requisite permit to do so, is substantiated. And because they've removed the front doors, the windows, which is a violation of the relevant legislation, both the municipal manager of the municipality and the AMAFA officials considered that the municipality was not granted the requisite permit, but only an in-principle approval. The removal of the windows was in violation of Section 33 of the KwaZulu-Natal Heritage Act. Therefore, the agency failed to exercise its oversight function with regard to the refurbishment of Mzimkhulu, as the agency had already granted the municipality an in-principle approval but not the permit. They should have held continuous monitoring of the landmark site to ensure its preservation. I also found that the allegation that procurement process followed by the Mzimkhulu in appointing service providers for the refurbishment of the Memorial Hall was not in accordance with the procurement processes and was in violation of Section 217 of the Constitution. The municipality failed to follow a competitive bidding process in the appointment of the service provider, so consultants and VA consulting. Both these institutions or entities were previously involved in the project and therefore had ultimate knowledge about the project. Especially Loyiso was involved in the feasibility study and thereafter was appointed as the implementing agent of this process. Buyeye was a subcontractor of Loyiso Consulting during all this process. So that is a violation of Section 217 because it gave these companies a competitive advantage over the others. So the municipality exposed itself to non-completion of the period of the project when it allowed the appointment of a contractor on which it had not conducted any due diligence, and it made payments directly to this entity with whom they had not direct contractual relationship. Because when Loyiso failed to perform their functions, especially on the construction side, the municipality then conducted a session with the approval of Loyiso, but then appointed Sifiso. And they didn't have a contract with Sifiso, but with Loyiso. So they failed to adhere to the SLA entered into between the Loyiso and the municipality. The expenditure incurred by the municipality in the refurbishment of the municipality from May 2015 to March 2016 constitute irregular expenditure, in that it was an improper conduct on the part of the municipality. I found that the municipality failed to exercise oversight over the municipal administration. In fact, that allegation that the municipal council failed to exercise oversight is unsubstantiated because we do have proof that the council was informed about the project and they were giving direction on how they should deal with the matter, and they ended up saying they should terminate the contract with this Loyiso Consulting. The remedial action ensured that the municipality revises its supply chain policy to provide for compulsory disclosure of any conflict of interest between prospective contractors and the employees of the municipalities. Ensure that the municipality revise their supply chain policy within 60 days to also provide that if they appoint an implementing agent in case of the turnkey project, their subcontractors need to be registered in their database. Ensure that Mzimkhulu local municipality submits their application to AMAFA, KwaZulu-Natal, so that they can get the required permit. so that they can proceed with the renovations. AMAFA KwaZulu-Natal to ensure that it adjudicates the application submitted by the municipality within the time frame provided for in terms of the KwaZulu-Natal Heritage Act. And I must indicate that on meeting the municipality, we agreed that they need to, with speed, proceed with this particular project, because since we requested them to stop until we issue the report. The final report is a matter relating to, in fact, not the final one. Yes, there's a matter we've investigated against the Premier of the Western Cape, again, Madam Zille, the Premier. The complaint was lodged by Honorable Dagmo, a member of the African National Congress in the Western Cape Legislature. In the main, it was lodged in terms of the Executive Members Ethics Act. In the main, the complainant alleged that there was an exchange of emails between the Premier, the Director General of the Western Cape, and senior officials of the Western Cape around September and October 2014. In the said correspondence, the Premier allegedly actively supported a process which resulted in the procurement of computer tablets. This is an allegation for the use in certain schools of the Western Cape, and that paper video, an initiative co-founded by her son, Mr. Paul Murray, was given preferential treatment by both the Western Cape Education Department and the Department of the Premier of the Western Cape, in that the tablets were delivered to him to load paper video resources on 250 tablets. It was further alleged that by participating in the process of procurement of the tablets for the use of a son's product and marketing and promotion thereof, the Premier's conduct is in violation of the Executive Members Ethics Code by advancing his son's business. Upon analyzing the complaint, I decided to investigate whether the Premier communicated with the Western Cape Department of Education senior officials, the DG and MEC Shafa, around September 2014, and also investigated whether the communication with the DG and senior officials and MEC violated the provisions of the Executive Members Ethics Code. Found that while the specific allegation that the Premier was in 2014 improperly involved in the procurement process of certain computer tablets for the use by public schools in the Western Cape is not borne from the facts and evidence at my disposal. My investigation, however, revealed evidence that the Premier's relationship with her son in the matter constituted private interest which sufficient to influence or appear to influence the exercise of her official duties. The Premier engaged the MEC and Director General to escalate performance by the supplier for the delivery of the said tablets in order to facilitate access of the tablets by her son. Even though her son was employed as a teacher within the Western Cape Department of Education, the access to the tablets was not secured as tools of trade through normal departmental channels, but through the intervention of the Premier, which created an appearance of impropriety. The access facilitated by the Premier enabled the Sun's company, Video, to utilize its software and educational resources through the use of the tablets during the revision project, primarily intended to benefit, in fact, as a public benefit exercise, inadvertently had the potential of promoting her son's business. I think the engagement with the Premier, she reflected and indicated that how this project benefited a lot of matriculants, and it's such a brilliant process, and how the son is very much engaged in community work and helping the disadvantaged. I also found that the allegation that the Premier's communication with the Western Cape officials, DG, MEC, violated the provisions of the Executive Members Ethics Code, this allegation was substantiated, because by intervening in the execution of the contract for the delivery of the computers, in order to ensure that the son can use these tablets, she exposed herself to a risk of a conflict of interest between her official responsibilities and her private interests. So Section 136(2) of the Constitution requires the Premier not to expose herself to any situation involving the risk of a conflict between her official responsibility and her private interest. So in this instance, she violated the Constitution, especially the Executive Members Ethics Act. The Premier's involvement in the process that has resulted in the securing the access by her son's company has exposed her to this risk, and further consequently has led to the violation of Clause 2(3)(f) of the Code. Members may not expose themselves to a situation involving the risk of a conflict between their official responsibilities and their private interests. So the test is not actually the conflict of interest, but a risk of conflict is sufficient to constitute a violation of the code. So the Premier's involvement in the process has resulted in securing access to this, and that's a violation. Accordingly, the Premier appears to have used her position to benefit her son, and because she exposed herself to this process. Even though the Premier averred that the MEC Shaffer was aware of the fact that Mr. Mare was her son, the Premier failed to declare such private interest in her engagement with MEC Shaffer, because she alleged, when she responded to a Section 79 notice, that she wrote an email to the DG MEC, but that email was declaration of to deal with the conflict of interest, whereas it's not clearly saying that. The email is just saying facilitate this for this person and this person, so that it can benefit. Definitely it benefited the matriculants, but then unfortunately that created a serious challenge, because the test here is not about conflict of interest. The test here is about risk of conflict, which is sufficient. So the remedial action is that the President of the Republic should, in terms of Section 35B of the EMIA Act, within 40 days after receiving this report, submit this report and comments of my findings to the National Council of Provinces. Chairperson of the National Council of Provinces must, within 30 days, ensure that this report is processed in accordance with the applicable rules of the National Council of Provinces. The Speaker of the Western Cape Legislature must, within 30 days from this report, table it before the Western Cape Provincial Legislature for it to take appropriate action. I think this report as well, I've indicated to the President that this should be a step where a lot of the members of the executive should be taking cue on that you cannot just say, but this was benefiting the people. But the main issue is that exposing yourself to that risk is in sufficient test. The Mbalula report, I investigated this again under the Executive Members Ethics Code. It's an EMIA matter. The allegation that Mr. Mbalula undertook a trip to Dubai with his family 28 December 2016 to 3 January 2017. I think it was around 5 days. The complaint was lodged by the DA, Member of Parliament, because all EMIA matters are supposed to be lodged by members of Parliament. No member of the public can lodge a complaint in terms of this legislation. But again, the head of AfriForum also lodged a complaint to the Protector. And a further complaint was received 10 October 2017 by a member of, Mr. His complaint was primarily based on an article published in the news. The allegation that Mr. Mbalula paid 680,000 for a Dubai trip bankrolled by a sports supplier, Sedgas. It was alleged that Mr. Mbalula was still a Minister of Sports and Recreation. He undertook a trip with his family, and this Sedgas is a supplier or a service provider of SASCOC, the South African Sports Confederation and Olympic Committee, which falls under the auspices of the Department of Sports and Recreation. Technically, Sedgas is a technical sponsor or supplier of formal clothing worn by the Team South Africa. It was alleged that the trip cost 680,000, and the company paid for Colt Raymond uniforms, paid for this trip. Mr. Mbalula and his family were accommodated in a hotel in Dubai, and he was the member of the parliament by that time. There was it's all these allegations. So Mr. Mbalula apparently issued a statement 9 October in response to the allegations, where he stated he wished that the matter would not enter public space. He, however, confirmed that he and his family did undertake the trip, but denied that it was a gift. And Mr. Mbalula stated that he had no direct conflict of interest arising from this trip. Mr. Mbalula reiterated that his family was responsible for financing this trip, and he used the family resources. And upon analyzing the complaint, I decided to investigate. In fact, the emir doesn't give me that discretion, but I'm obligated to investigate. So the investigation was initiated, and I also investigated whether any irregularities or improprieties in the funding for Mr. Mbalula and his family to travel to Dubai, and whether that constitutes maladministration. Also under investigation was whether Sedgas Sports, who provides SASCOC, a sports federation under the auspices of the department, sponsored the trip of Mr. Mbalula. I found that the allegation that the former minister, Mr. Mbalula, violated the executive members' ethics code when he undertook a family vacation was substantiated. Indeed, the trip was undertaken, and what was peculiar is that neither Mr. Mbalula or his family or office arranged the trip. The bookings were made by a certain Mr. Siwela on behalf of Mr. Mbalula, and Mr. Mbalula makes no mention when he responded to the Power Protector, no mention of Mr. Siwela or the relations. However, the response which was received later was that Mr. Siwela was not asked by him to do the bookings, but initiated same out of his own volition, because Mr. Siwela just recommended this travel agent, Moonlin Travel. There is nothing untoward in the minister taking his family on a trip abroad, and of which that's what I also agree with. But then the challenge is when Mbalula departed for Dubai, the trip was not paid, and he is neither a client of this Moonlin Travel, but then was recommended by this Mr. Siwela. Mr. Siwela was a client of Moonlin Travel. He then stated that he had the necessary funds which he verbally asked for a loan from Mr. Docrat so that he can cover the traveling. And there's no evidence in my possession that Mr. Mbalula requested or obtained a loan prior to departure. Evidence in my possession indicates that the trip commenced, the payment of the trip only commenced the following year, 17 February 2017, following the repeated demands by this Miss Bayliss from the travel agent to settle the costs. It had to take payments from Sedgas Sport and debtors collectors practicing under the name and style SVG Legal and Forensic Investigative Services, for the trip to be settled. So by leaving the country for Dubai without making necessary payments arrangement for the trip and not even knowing the cost related thereto, Mr. Mbalula acted in a way that is inconsistent with the position of a cabinet minister. So this is purely looking at him being a cabinet minister. His conduct was grossly at odds with the provisions of Section 96 of the Constitution, the Executive Ethics Code. Therefore, the information and evidence obtained during the investigation conclusively suggests that Mr. Mbalula's conduct was inconsistent with the standard required by the Constitution. His conduct in traveling to Dubai without paying for the trip exposed him to the risk of a conflict. Again, there's the risk of a conflict which we dealt with earlier. Doesn't mean there must be a conflict. The risk of a conflict is sufficient standard to be taken into consideration. So the allegation that there were irregularities and improprieties in funding and sponsoring this trip is also substantiated because when Mbalula boarded the plane, he did not know how much his family vacation in Dubai was going to be. And I mean, the total, he was under the impression is 600,000, but the cost escalated to 680. But that was due to the fact that there were delays or there were changes which were done when they delayed to acquire the visas to travel to Dubai. So Mr. Mbalula and is still not a client of Moonlim, but as I've indicated, it was Mr. Siweya. It was also inappropriate for Mr. Mbalula to enter into a what is termed loan agreement with Yusuf Dokrat, the director of a business which is Setgas. So Mr. Dokrat is the director of Setgas. Setgas is doing business with the SASCO. What is peculiar about this loan is that it was entered into after and when Mr. Mbalula could not pay for the trip. But Mr. Mbalula said he was going to pay for the trip because he planned to sell his property, or there was a stage where the property was on sale. So he thought he will settle the bill using the sale of that particular property. During the investigation, the three, Mr. Mbalula, Dokrat and Baylis, considered to the payments which were effected from NetBank by Raymond Uniform. So this Raymond Uniform is owned by a cousin to Mr. Dokrat, so it's a family business. So it is admitted that there was an exchange of funds between Mbalula and Dokrat, and Mbalula then finally repaid the loan which he got from Raymond Travel, or from Dokrat through Raymond Travel. I do not accept that the arrangement between them constituted a loan, since the transaction has not been reported. In fact, even if Mr. Mbalula paid or repaid the funds, but then again he exposed himself to this risk of a conflict. And Mr. Mbalula was saying he did not know that Mr. Dokrat is a director of Setgas, but they've been friends for more than 2 decades, so surely he should have been aware of that particular issue. Therefore, there was an undisclosed and unmanaged conflict of interest between Mr. Mbalula's responsibility to act in the best interest of his department, government, and his private interest. Again, that issue of the interest or the risk of exposing yourself. I think in engaging with Mr. Mbalula, he was even told that, unfortunately, members of the executive, in terms of this constitution, they are expected to act as saints because we are regarding them to be holding very strategic positions, and we don't expect such issues. For remedial action, I direct the President to take note of the findings I've made in this report with a view to sharing it with other members of Cabinet as to ensure that they guard against this conduct from happening in the future, since that's the main intention of our reports and our remedial action. We address the root causes of maladministration. And I'm not taking any remedial action against Mr. Mbalula since he's no longer a member of the executive and is not even a member of parliament. I also direct the Cabinet Secretary to ensure that subsequent to the appointment of ministers and deputy ministers, they are within 60 days of appointment trained about their constitutional obligations as envisaged by Section 96 of the Constitution, as well as the Executive Members' Ethics Code. I further directed the Director of Financial Intelligence Center to take urgent and appropriate steps to investigate the source of 150,000 cash that was paid to Moonlight Travel. Lastly, I directed National Director of Public Prosecution to also take urgent steps to investigate whether funds used to pay for Mr. Mbalula's trips were not proceeds of any crime. I look forward to a full implementation of the remedial action of these cases, and where there are disagreements, parties are free to take my remedial actions on review. And I must indicate that all government departments or all parties are obliged to implement unless taking the matter on review doesn't suspend the implementation, unless they interdict me. I think like what the Premier of Western Cape did to interdict the report so that the judicial review can be concluded. As I conclude, to all members of the public, our network stakeholders, the members of the media, executive, parliament, I wish you a blessed festive season and a prosperous 2019. Thank you.
Thank you, Public Protector. I'm now going to open the floor for questions, but before I do that, maybe I should indicate that shortly after the press conference got underway, we were joined by the Deputy Public Protector, Advocate Kevin Malunga, as well as the Executive Manager for Administrative Justice and Service Delivery, Ms. Protector Busisiwe. Now let's see by a show of hands who is going to go first. I'm going to plead with you to indicate your names as well as the media houses you represent before you ask your question. We'll start here, and then we'll go to the other side. I have 3 hands up at the moment. We start this side, then we go to the other side. Please introduce yourself and fire away. Thank you.
Sorry, is this okay? Is it working? I'm not sure if this is working. Is it working? Okay. Sorry, just a few queries. If you could just provide it, I mean, obviously the matter involving the minister having boarded and the status of the investigation into whether that is now a formal investigation or whether you are still in the preliminary investigation phase, whether you've decided to pursue that. On the Helen Ziller report, I'm just trying to understand. So you basically saying that she had a conflict of interest because she provided assistance for her son to offer free mass education to underprivileged children by allowing them access to tablets. My understanding is that conflict of interest is when you in your official capacity act against the public interest. Can you just unpack the basis of that legal finding? And then with Mr. Mbalula's matter, there have been suggestions that there was some kind of criminality involved, that this payment that was given to him could potentially constitute a bribe or some kind of form of corruption. You don't seem to make any such finding, and you stress that he did repay the majority of the money. But do you believe there was anything potentially criminal in his conduct? Thank you.
Good afternoon, Barry Bateman, Eyewitness News. Public Protector, you refer in your remedial action in the Mbalula investigation that there should be a referral to the National Prosecuting Authority to further investigate whether the cash payments were the proceeds of money laundering. In my understanding of the Prevention and Combating of Corrupt Activities Act, this 300,000 rand, this holiday that was paid for by the sports supplier to SASCOC, and given the fact that Mr. Mbalula was the Minister of Sport at the time, does this not, on the face of it, constitute a gratuity that should in fact be investigated for corruption? Is that something that you could have included in your report? Is it something that you believe, having looked at the facts? Thank you.
My name is Baldwin now. I just wanted to find out with regard to the Mr. Dondo Mkhwebane matter. What is the nature of the offense that he was convicted of? Does it, if it's so serious, does it qualify for him to be discharged of his duties?
Are there any more questions from the floor? If there is none, I will then proceed and ask the public protector.
Okay, thank you for the questions. Karen, the issue of Minister Pravin Gordhan, I think there's that complaint from the member of the public, which was received in 2016. And you must understand that in terms of the Public Protector Act, investigation includes preliminary investigation. So it's a process where we are collating information, where then the Public Protector will decide whether the allegations are substantiated or not substantiated. And on the issue of Helen Zille, I think if you can read our report very clearly. I met with the Premier and with her legal team, and it was very clear that we understand and acknowledge that the Premier's son is doing good work or great job for the people at the grassroots, and especially working at Khayelitsha, I think. The main thing here, I said read section 136, is it section 136, where it's very clear of the Constitution. It says that there must be a member of the executive should avoid any potential risk of a conflict of interest between their interest, the private interest, and their official interest. In this particular instance, I also engaged with her and I said, let's compare apples with apples. I have a son of a minister whom the minister will be approaching you as the Premier and informing you or informing your DG to, assist that minister's child to provide a certain service. And at the end of the day, that is not, because the issue, we need to deal with perceptions, we need to deal with that potential risk of exposing yourself. And I must indicate that that paper video, it later transpired that because at the end of the day, she was also arguing that, but my son never got any benefit. That was a project which was free. But it transpired that the company is registered. Again, it has a lot of questions. Did the son also require or acquire any relevant permission from the Department of Education to conduct business? But that was not the focus of our investigation. And the son has been placed in such a way that they've benefited. So it's purely the exposure, because it says it requires the Premier not to expose herself to any situation involving the risk of a conflict between her official responsibilities and private interest. So in this particular instance, she has exposed herself to that risk of a conflict. So the standard is very clear, is exposing yourself to a risk of a conflict. Whether there was a conflict of interest or not, that's another issue. So the Minister Mbalula, I think possibly you were not listening to me when I was reading the finding, because I requested that the Director of Financial Intelligence Center to take agent step to investigate the source of the 150,000 cash that was paid to Mundlin Travel. And the second one, I think it will also address Barry, the issue of, because a criminal conduct, if NPA is investigating whether those were proceeds of money laundering, surely the investigation won't only focus on that. Surely they will have to investigate whether indeed it was corruption and whether there's any case for Mr. Mbalula to answer to. On the issue of Mr. Mkhwebane, I think it also needs to be clear that it's not about the crime, the traffic offense. The issue is about non-disclosure. I mean, you are an official who's holding a very high post where we expect you to behave in a manner of honesty and integrity, holding the resources of trillions of resources of this country, and you only complete the form. And that was not the first time, because when he applied for the DDG post, that was brought to his attention. And again, this is not a crime where possibly it's a speed fine, you fail to pay, and then you don't know, because that happens. You discover later that you have this. This one, you appear in court and you are found guilty for that. Therefore, it's upon you to do that. And the standard, again, is any public official or public servant who applies for any post, that's why they complete this as a Z83 form, because it allows them to also be upfront to the potential employer about, and again, it reflects honesty. So it's about that. It's not about the issue of what kind of offense was committed. On that one, it's up to the president what disciplinary process they take in this particular instance. Thanks.
Thank you, Public Protector. Do we still have any more questions from the floor? Okay, I see Barry and Karen wants to take a second bite at the chair.
Yes, that's how we roll. Yes, no, you can start with Barry.
Thank you, Public Protector. It's just clarity on the one remedial action, and it's just some clarity on related to the actual investigation. You say that the FIC must investigate the source of the 150,000 Rand cash paid to the travel agent. Now, I understand that 150,000 Rand was made in two separate cash payments of 75,000 Rand each, one at a bank in Brooklyn, one at a bank in Hatfield. Now, in the age of EFT and people, the way they pay for certain things, did Mr. Mbalula offer any explanation for why these payments were made in two tranches of cash at two separate bank branches? Thank you.
Okay.
Just to follow up to what you were saying about the Zilla story. I mean, you're setting a very high bar, considering we've had a number of instances of alleged nepotism involving government officials, involving very senior leaders and their family members, not least all in the VBS matter. Are you hoping that this kind of reasoning is going to be sustained? Because, I mean, the obvious differentiation here is, as you pointed out, that he did not derive any financial benefit from this. But we have numerous other instances in which it's alleged that very senior leaders, for example, of the EFF, have family members that have direct beneficiation and went to Parliament and participated in processes where that BBS matter was actually discussed. I just, in terms of the Zilla matter, I know she's litigating against you at the moment. You said in your response to her challenge to your tweet report that leaders were almost, I think, legally obliged to be very cautious about making comments that could be perceived as racially divisive and promoting violence to any racial group. In light of that, are you pursuing any other investigations, particularly given the recent comments of BLF leader Adile Mthethama with regard to wanting to kill white people and their kids, I think. Thanks.
Thank you, Mr. Commissioner.
Barry, I was investigating under the executive members ethics code. I'm not a criminal investigator. Therefore, that's why I'm referring this to, I'm allowed in terms of the Public Protector Act to refer to proper agencies to deal with this. I mean, that's the core mandate of FIC. So this one will have to be explained there. Mr. Mbalula will explain there. The Zille matter, the high bar, Karen. I think if you've listened to me when I was saying I spoke to Mr. Mbalula, because Mr. Mbalula is saying, but this man is my friend for so many years, and it's like, so I was saying to him, unfortunately, even to Premier Zille, as members of the executive, under the executive members ethics code, and including ourselves, you need to behave like a saint. You mustn't have any sport. Therefore, if you are going to be the minister, premier, president, you need to be making sure that you remove, or you make sure that you don't expose yourself to that. So any minister, hence the remedial action, we're saying, President, can you make sure that any person who's appointed within 60 days, they are trained on executive members ethics code, so that they don't expose themselves to this. And again, that bar should remain high, and it should be what standard we should be expecting ministers, deputy ministers, premiers, MECs, president, deputy president to be acting. Not expose yourself, not having members of your family being benefited over the other public, or in fact members of the public. So EFF, VPS, they are not falling within my jurisdiction. Those ones, I think the committee in Parliament which is dealing with the integrity, they will deal with them as members of Parliament. They don't fall within the mandate of the Public Protector. I think you should know that. The issue of Mkhwebane is not a member of the executive, so I don't have jurisdiction over him. I wouldn't be pursuing that. But then instances where members of the executive are implicated, I will definitely, and I am investigating those complaints. And remember, EMIA complaints, I think I've been saying several times, and I think I'll appreciate it if members of the media can understand this. I'm obliged to investigate. I don't have a discretion to say I've decided not to proceed with this investigation, or I've decided to refer this matter to another institution to investigate further. So this one of Ms. Zille, and I must indicate that in the report, go and read the report, there is very clear evidence that now the son is registered, the son now is benefiting financially. By then he never benefited, but then by that it exposed the company to, or that software to further business opportunities which they are dealing with. So I think the issue here, Karen, is the rule of law in South Africa should be applicable to each and every citizen or member of the executive, member of the public, irrespective of what are the intentions of that particular member of the executive.
Thank you, Public Protector. I think we have now come to the...
I think there's the question about Mr. Mkhwebane. Yes, and I think what I just want to highlight the fact that Mr. Mkhwebane does not lead an organ of state. In other words, remember the Public Protector has jurisdiction over allegations of impropriety by state organs, and he has the BLF, and in terms of the law as we know it, the South African Human Rights Commission in particular has been dealing with racism complaints and issues. So while obviously we may have views and quite concerned about that kind of narrative and rhetoric, but we don't have direct jurisdiction over that specific matter. So I think it will be Human Rights Commission and Equality Court and so forth, yeah. And I was joking to the public protector that we certainly would even offer to train the executive on this thing, because it seems to be a recurring problem, this conflict of interest. Not even journalists are immune from conflict of interest. So it's something that we really all need to take seriously.
Thank you, colleagues. Thank you, Public Protector. We have come to the end of the presser. It's adjourned.